Good evening, Assalamu alaikum rahmatullahi wa barakatuh, and welcome to News in Focus. My name is Faraz Patel. We'd like to thank you, the viewer, for staying with us here on Hilaal TV, DSTV channel 347. Now, on Tuesday, the Constitutional Court upheld an appeal court ruling which struck down a provision of the Citizenship Act in terms of which South Africans were stripped of their nationality when they acquired citizenship of another country. In a unanimous ruling penned by Justice Stephen Majid, the Apex Court held that Section 61A of the Act was irrational. That meant all those who have lost their citizenship as a result of the provision in the Act from its promulgation in October 1995 will be deemed to have lost their citizenship. Joining me now to discuss this, I'd like to welcome immigration lawyer Ashraf Essop. Ashraf, assalamu alaikum wa rahmatullahi wa barakatuh, and jazakallah so much for joining us.
Walaikum salam wa rahmatullahi wa barakatuh. My pleasure to be with you.
No, it's an absolute pleasure. Ashraf, let's just break this down for the layman out there. I'm sure a lot of people don't live under a rock, but if they lived under a rock, they've decided to read the news this morning that, of course, this is the Constitutional Court decision. Discuss it, please.
So for them, it will be a time to celebrate because what was deemed to have been automatic loss of citizenship has now been reversed. As mentioned, back to 1995, but the legal challenge is about 10 years old. The applicants, being the Democratic Alliance, took the Minister of Home Affairs to court, alleging that sections of the Citizenship Act, specifically Section 161, that deems you to have lost your citizenship under the following circumstances. Apart from marriage, and if you are a minor, then if by a voluntary act you took up citizenship of another country, that resulted in automatic loss of your South African citizenship. Now, this High Court actually agreed with the Minister of Home Affairs. The High Court reasoned that, yes, there was automatic loss, but because of the security of the Republic, you had to ensure that you took steps that was already provided for in terms of Section 6.2 to apply to the Minister of Home Affairs to retain South African citizenship. And in practice, if and when the minister replied, you obtained a certificate, and that certificate enabled you to apply for citizenship of another country. So therefore, you were protected from the automatic loss of citizenship. The Supreme Court of Appeal said no. Citizenship is such an important component of a citizen's existence, primarily because the Constitution safeguards citizenship. It makes it clear that no one may be without a citizenship. Subsequently, the Supreme Court of Appeal then reasoned that your citizenship was a gateway to all other rights vouchsafed in the Bill of Rights. The Bill of Rights is part of the Constitution. It's very, very important because it contains a number of rights. One of the rights that it contains is the right to leave and re-enter the Republic, a right to a passport, a right to earn an income, a right to education, etc. Now, all of those rights were safeguarded only through possession of your citizenship. And the fact that you didn't know that there was such a law, or alternatively, you acted in contrary to the prescripts of the Citizenship Act, and then you lost your citizenship, was too much for the Supreme Court of Appeal. And ultimately, the Constitutional Court on Tuesday upheld the reasoning. Now, what was the reasoning? It was that there was no rational connection between the provision in the Citizenship Act and the loss. I mean, what was it protecting? Now, understand that the 1995 amendment just came after the 1994 democratic elections, but its history lay in the old Citizenship Act. And there, as you could imagine, based on the old crown and king, they wanted you to be loyal British subjects. And so they jealously guarded the fact that if you lost your citizenship through a voluntary act, well, that was quite devastating to the country, and they wanted to protect it at all costs. So this was the rationale. This was what the Constitutional Court was saying was irrational. There was a deep explanation by Justice Majid regarding the prevalence of dual citizenship now in the world. And initially, there were only a handful of countries, and today, up to 76% of countries now allow their nationals to have dual citizenship. So basically, what it found was that the provision was unconstitutional because it was irrational, and the devastation on the citizens was too much to bear. Because of that, it now is deemed the legislation to be invalid from inception, 1995. So already you're having a number of people already asking, well, we lost our citizenship, now what happens? So what we understand is the Department of Home Affairs has established or will establish a special online platform or portal where you can make application for your citizenship to be reinstated. But the consequences were quite devastating in some of the cases that we've dealt with. People that were born South African citizens, lost their citizenship, became permanent residents in South Africa, and had to now enter and leave on a foreign passport while their families were here. Their children were deprived of permits in certain cases. I mean, this all happens as a daily event at Home Affairs for various reasons. And so they were now caught up in the whole, let's say, the unfortunate circumstances of such a piece of legislation.
Yeah, Ashraf, and that's why I want to come to the next question. Section 6.2, in which Home Affairs had counted on a loss of a citizenship through a voluntary act and a potential application to the minister. I want you to touch on that because you've ended that part of the answer leading up to this question. So let's talk about that section right over there.
So Section 6.2 provided that you had to make application. So you intended to go abroad, study, marry, and remain, or acquire your citizenship of another country. Look, recently, I think about 3 years ago, the UK now permitted citizenship through maternal pathways. So you may want to avail yourself, or the difficulty of getting visas on a South African passport where you had European ancestry. I mean, you can imagine that most of these beneficiaries would be people who have already have some other link somewhere else, or recently you would have seen citizenship by investment in a number of Caribbean islands and Turkey, etc. So what it envisaged was not that you were not allowed dual citizenship. That is a constitutional guarantee. What it envisaged was a process. And that process was itself capricious because A, you don't know when you get an answer. B, you don't know what the answer will be. I mean, the minister could easily refuse such a request, and we've seen this. And then you have to take that matter on review and say it's irrational, etc. But the process leading up to it was also found to be discretionary and therefore capricious. So the two go hand in hand. 6.1, automatic loss, and 6.2, having to go through the process of going to secure your citizenship first before you take the step to the next citizenship. So 6.2 is also, it hasn't been struck down as such, but it certainly will be of no effect going forward.
Yeah. Ashraf, then onto Section 8.2, where it speaks about stripping someone of their citizenship and the discussion regarding dual citizenship. So from my understanding, this section here allowed for there to be somebody who had been naturalized as a citizen in another country, which then gave, of course, the Home Affairs Ministry the powers to strip someone of a South African citizenship. Am I correct in saying that? And now, of course, this changes now with the Constitutional Court decision.
Well, 8.2 is deprivation, right? 8.2 is an act by the minister. It's got nothing to do with automatic loss. So automatic loss is as a result of a step taken by the citizen. 8.2 is a step taken by the minister for various reasons, such as if you made a fraudulent misrepresentation in your application, or you obtain your citizenship through fraud, which is basically what is covered in the news almost on a daily basis. You could see that people have come in from other countries, obtained false birth certificates. Aditya Chidimaya was a good case to point to.
Yes.
Now there, the minister would say, I intend to deprive you. So the word is deprive you of citizenship, or renounce your citizenship. Renunciation is also a further act by the minister. So in cases where the minister finds that the citizen is not deserving of citizenship based on fraud, etc., then he has the ability to serve notice. And this is very important. Only the minister may remove your citizenship ultimately, and only the minister has that power to invite you. And if he doesn't do so, then we say that the matter is procedurally unfair and subject to a judicial review. So at the end of the day, deprivation is an act by the minister and results in renunciation. You, of course, would be familiar with the famous Gupta case,
Yes.
where the children were prevented from obtaining passports. However, there was no clear renunciation or deprivation of citizenship. I think the last person to have suffered that, or is in the process of suffering it, are the assassins of Chris Hani. At some stage, you'll see.
Ashraf,
and currently there's.
Ashraf, I have to
Yes.
unfortunately stop you there because we have to go for a break. But of course, we will continue this conversation after this. Do stay tuned. I'll have more for you on News in Focus. Welcome back to News in Focus. I'm still in conversation with Ashraf Essop, an immigration lawyer, on the Constitutional Court ruling that occurred on Tuesday. Shukran so much for staying with us, Ashraf. Ashraf, I want to turn to the rights of a citizen with regards to 36.1. Given this ruling, how important does that section now come into play?
So 36.1 in the Constitution is what we call the limitation clause. So all rights that we enjoy in the Constitution are subject to certain limitations. Now, in this case, the court examined the rationale, as we've discussed previously, of why, under what circumstances, one would be deemed to have lost their citizenship. And there was no justification, or there was no balance in Section 36 of the Constitution to counter the court's finding that, so there was no justification in terms of Section 36 that could have countered the application, the court's reasoning that automatic loss of citizenship was unconstitutional. Usually, they would weigh that up against, is there a limitation? Why was this created? Does Section 36 outweigh the benefits extended to the citizen in this case? And they found there was no such justification. So the department did not argue that there was a legal and legitimate justification for the law to exist.
Ashraf, the court has stressed that this act set no criteria for how this should be exercised. I know, of course, the Apex Court is the be-all and end-all when it comes to decisions, but when it comes to any potential constitutional amendments, can we see something happening with regards to that?
The constitutional amendments or amendments to any legislation is always at the behest of Parliament. Courts do not make laws. Ministers do not make laws. The courts interpret the laws, and the minister has to execute it. Whatever mechanism the minister puts into place will be dependent entirely on the operational requirements of the Department of Home Affairs. But certainly when it comes to a matter being struck down and now confirmed by the Constitutional Court, remember the SC had already reasoned for the Constitutional Court. The Constitutional Court had to confirm the invalidity of the section. It has to go back to Parliament, and it has to be then amended, because only Parliament can make and amend statutes.
Ashraf, In terms of expats, I know this is a huge supposed win for any expats in South Africa. How does this ruling change it for them right now?
No, remember, this was not directed at expats. Expats may come into South Africa with their citizenship, and they may follow the process through the Immigrations Act, or if there was some kind of, let's say, birthright in terms of the Citizenship Act, where you were a citizen by descent, then they wouldn't benefit. This was to benefit South Africans who automatically suffered loss of their citizenship because they, through a voluntary act, took up citizenship of another country. But there was an interesting interlude. Mr. Plaatjes was one of the parties cited by the DA. Mr. Plaatjes lived in South Africa as a citizen, went to Korea, fell in love with a British citizen, ultimately obtained UK citizenship, and had children that were also UK citizens. At some stage, he found out, I think when he went to renew his his South African passport, they declared him to be no longer a South African citizen, having applied Section 6.1, saying that, look, you've lost it because you, through a voluntary act, you've now acquired citizenship of another country. And Mr. Plaatjes was then obviously aggrieved, but he couldn't do anything because the legislation was as it was. So this is clearly only a win for South African citizens. It doesn't apply to people who are already dual nationals. That means they come from another country and they acquire South African citizenship.
Ashraf, in terms of the test for the Constitution, how major is this ruling when it comes to that?
I think what we've seen is a tremendous exercise in how the judiciary deals with matters. This is very, very important because the Constitutional Court will only entertain matters that have constitutional value. So you can't, you have to actually prove that this was in terms of a constitutional right. And so the constitutional, and the matter wasn't opposed. I must make that clear by the department. So it was an unopposed matter, but the judge still had to rule. It's a massive judgment. It runs into 30 pages. It deals with dual citizenship. But the crux of it is irrational, therefore unlawful, therefore unconstitutional.
Ashraf, one final question. For those now who, of course, understood, if it's not just this interview, maybe they've seen others or they've read through different experts like yourself when it comes to what Tuesday's ruling had meant. So if you're a South African and want to become a naturalized citizen in another country, firstly, does this make the step much more better? And number two, of course, if you want to come back to South Africa and you had either your grandparents or a mother or a father that, of course, were born in this country, does this now make the process much more easier, or are there sections within the Act that are still going to provide some sort of layers for you to go ahead and execute this?
No, it's infinitely more better because your rights are now protected by a constitutional court ruling, and it has declared certain sections to be unconstitutional. So it does, and in fact, the fact that it operates with retrospective effect is even more better because those that were deemed to have lost it are no longer deemed to be non-citizens. You're now a citizen. So the mechanism still has to be unpacked as to how Home Affairs will deal with this. As to those people wanting to return to South Africa, now armed with the knowledge that they're still South African citizens and entitled to apply for citizenship through naturalization or through descent or whatever, they are also able to do so. But like I said, it's not aimed at people that are returning. It's aimed at people that had deemed to have lost it. So if you went abroad and you became a naturalized citizen of some other country and you were deemed to have lost it, you are part of the group that will benefit from this judgment.
Ashraf, Jazakallah so much for joining us here on News in Focus on Hilaal TV. Much appreciated.
My pleasure. Thank you.
That's immigration lawyer Ashraf Essop, just breaking down, of course, this Constitutional Court judgment. So it's going to be quite interesting now how this goes ahead. It's quite simple that if you, of course, were overseas, lost your citizenship due to certain rulings, you now have the opportunity to go ahead and reapply or return your South African citizenship back to you. Of course, it's going to be interesting for those who, of course, had been, would not say a victim, but of course, this ruling had affected them. This now allows them this opportunity to have it returned. It's a major landmark in terms of a decision, and of course, another great test to our Constitution. After the break, I'm going to be speaking to Jonathan Fowler from the United Nations Refugee Works Agency. Yesterday, the Palestinian government had declared that Gaza, who is currently under a brutal genocide, has now been declared a famine zone. I think everyone right now knows what that means. It's not just them going under tremendous bombing, devastating bombing. It now also means that they will have no food to eat. As we speak at this very moment, the Rafah border is closed. Israel is not allowing any aid to pass through. That in itself is another crime against humanity. And it's the innocent of Gaza right now that are continue to starve while a genocide is happening. I'll have that conversation with him after this break.